I appreciate it, especially when it's so nice outside, too. But my name is Gail Gottehrer. I am a litigation partner in the law firm of Axon, Veltrap, and Harkrider in New York and Connecticut. My practice is an interesting evolution. It's kind of along the lines that Craig described about embracing technology. I started out more years ago than I want to admit doing class action law and insurance and real estate law, which people kind of would smile politely, and employment law too, and say that's kind of boring, but that's okay. But the good news is now technology has changed it, and it's really a cutting edge practice because real estate law, commercial real estate law in New York is now about smart buildings. Insurance is about telematics and connected cars and how to underwrite them and how to insure them. They're about drones, surveying property and assessing accident claims. And it's all become very modern, very much about privacy and very much about data. And that's what I focus on now. So we're going to talk about, in case you needed more proof, that data is central to litigation, and it's not the future, it's the present. I'm going to talk about some cases, some published cases, which are only a small trickle of what's out there, and what decided cases are only a small fraction of the actual cases that are out there, but hopefully will prove to you that this stuff is incredibly valuable, can really differentiate you as a lawyer and confer value to your client. And you just have to know what to look for, what to ask for, and how to know if you've gotten what you're looking for. And please feel free to ask questions as I go along. So when I started practicing, again, more years ago than I want to admit, everything that we used as evidence in litigation was paper. So unfortunate junior associates were shipped off to warehouses where we looked at stacks of bankers' boxes up to the ceiling, and we would open, I see some of you chuckling, we would open the first box that you'd pick at random. You didn't know if it was from you didn't even know whose stuff it was. They were sometimes mixed together, much less the most relevant custodian. You would start at the beginning of the box, go through paper, and you'd put a tape flag on it, very high tech. A tape flag, maybe you had a color coding system, maybe not, and you tag it, and then you would hope that your copy service came in behind you and actually copied the right documents. And if they didn't, you would have no way in hell of knowing, because you went on to the next box, and there was really no indexing system, and there was no way of validating it. You hope for the best, kind of. And then once it came into your office, we didn't have scanners back then, it's sad, but the rule was never let the senior partner near it until you've made multiple copies, because he'll spill coffee on it, and then you'll have trouble attaching it to the summary judgment motion. So you'd make more copies, and you'd put them in file folders. That's the way we did litigation, and that's the way we litigated extremely big cases. And I can tell you, as a class action defense lawyer, I had a case for Culligan, the water company. They had invoices, and this is not that many years ago, on that onion skin paper that was folded in eighths, and that's to review it. We had to undo that, or we'd have to unstaple it and then restaple it. But the good news and bad news is that's not how things are done anymore. So that's not the kind of information we collect. Everything is data. And to the extent any case has a smoking gun, which is questionable, today that smoking gun is going to be an email. It's going to be in digital form. It's not going to be paper unless somebody has been really sloppy and printed out that email. That's damaging. But if you're looking for paper, you're missing what's valuable to your client's case or your client's defense. So with that, it's more than kind of a niche area to understand e-discovery, because it really is all about discovery. You have to know what to ask for. We request documents, any and all, which is another issue, but a document, you need to know, do people have voicemail? Do you store your voicemail? Do you have audio files? Does your company send voicemails? Do they transcribe them automatically and send them to your email? And if so, then are they backed up? These are things that matter, because those kind of voicemail messages are evidence that you may well want in a case or in an investigation, but you have to know to ask for it. Because if your definition of documents isn't descriptive enough, or if you don't get it and you don't know to follow up, your opponent probably isn't going to volunteer that information. There's all sorts of information. So to know, does the insurance company you may be suing or representing, do they use drones, and where does that data go? How long do they keep that for? What do they record? What do they use that for? So you have to know what to ask for in discovery. Then you also have to know to make sure that you got what you asked for. And you really need to have, you don't need to know the absolute technical things. You can have a vendor for that or someone who's more in the weeds for that. But you have to kind of have a sense of what you were looking for. And if you don't get any PST files, then you have to know there's something wrong with that production. You have to be clear that it wasn't garbage in, garbage out despite your best efforts. Then beyond that, at a deposition, you have to know how to introduce these documents or this data. So you have to know how to question somebody about their Twitter account or their Facebook profile, which can be extremely relevant in a deposition. And that continues on to how to use that data in summary judgment motions, at trial, how to get it authenticated, how to object if it's used against you. And you need at least some basic understanding of all the new and emerging technologies, not by any means to be an expert, but enough to ask the right questions, know what you need to know, so you get it in front of a jury who all likely use Facebook and Twitter. You don't want to look like you don't understand what it is, because the jury's going to look at you a little strangely. So this is going on today, and as the cases we're going to talk about show, this is here today, and it's increasing by the day, because as Craig said, a lot of information now will never be created on paper. Most of you who deal with big companies or work for big companies know so many things are created. We don't have logbooks anymore. We don't have, gone are the days of ledgers. Everything is an Excel spreadsheet. So you have to be comfortable with this kind of data, knowing where it is and how it can help you. So telematics devices, we were talking about cars. Somebody asked about cars a little while ago. So telematics devices are kind of like what you see Flow and Progressive on the commercial. It's very often a dongle or sometimes through your cell phone that you put in your car, and your insurance company frequently will give you a discount for it. It records a tremendous amount of information. So it records where you are, where you're driving, what hour you're driving at, if you take a lot of hard turns, if you brake very hard. You should read the representations in the agreement, because it's supposed to be used only to give you a discount. Progressive recently changed its policy and informed certain people that they weren't the best drivers, so they were going to raise their rates based on that. But in any event, it's a tremendous amount of information that goes to your insurance company. It's often resold. And there's a concern, it's an issue within insurance that potentially can be used for redlining. Are you driving your car in a bad neighborhood? Is that going to be used to determine rates? Things like that. So there are tremendous risks. But it's also been used in litigation. So recently, telematics data led to a criminal conviction of a gentleman in the United Kingdom who was driving and was involved in a hit and run that killed a pedestrian. So the police, they had experts who understood data. They analyzed the data from his car and found that at the time of the accident, he was driving more than 20 miles over the posted speed limit, which of course he had initially denied. But when confronted with that evidence, he pled guilty to dangerous driving and was sentenced to more than 3 years in prison. So there were witnesses to that hit and run. He denied it initially. So the car, his car and the data in the car was the evidence against him that led him to plead guilty and serve 3 years in jail. So similarly, in the United States, there was a case with a Progressive insurance telematics device was in a car of a father in Cleveland, and it helped him persuade a jury that he hadn't committed murder. A gentleman named Michael Beard was accused of suffocating his infant daughter at 4:45 a.m. That was when the medical examiner determined she had died. And he had come home following a shift at a hospital. So he came, found her, called the police. They accused him of killing her. Data from the telematics device in his car was introduced at trial and showed that he had turned the car off in front of the house at 4:44 a.m. and turned it back on 3 minutes later. And after deliberating for only half an hour, based on that information, the jury acquitted him. So this stuff is being used in criminal trials. It's being admitted because it's being validated by experts and by the technology, and it's having serious consequences. Another interesting case involved a Jeep Renegade that had a Uconnect telematics system, which is one of those devices like the systems like Craig showed the picture of, that records information about you. It connects you. You can put in your iPhone. You can play your playlist. You can get on all sorts of internet sites. So this gentleman embraced the whole connected home idea. So in addition to having telematics, he had a Nest home security system in his house, and he was robbed. And a combination of the photos, the tape that the Nest device took, combined with information in his Uconnect system, so the telematics system in his car, he noticed that there were 3 new identifying names in his system. So as opposed to saying Joe's iPhone, which was his, the next time he got his car back, they robbed his house and stole his car, gets his car back, turns it on, sees 3 new names. So the police go on the internet and look up these names, and combined with the pictures from the Nest footage, they identified one person and arrested him, and they have leads to find the others. And so the person that they identified, based purely on this telematics data and the Nest data, pled guilty as well. So that's a case out of Baltimore. And then in another case back in the United Kingdom, a gentleman named Neil Heron, he was able to prove that he hadn't been speeding. He was pulled over and charged with driving 10 miles over the posted speed limit. He again denied that he had been speeding. Go figure, at the time of the accident, he was testing out a new telematics device in his car. And that device, the data from that, let him show that the car had been traveling actually far below the speed limit and supported his claim, and based on that, he was not convicted. So these are just recent cases. This information is being used, and it's a tremendous resource. Telematics, it gives you all sorts of useful information. It's helpful, it gives you warnings, but it's being admitted as evidence, and it's information that in cases that you're handling, you may want to know and may want to think to ask for. You may need to subpoena it from insurance companies, you may need to subpoena it from automakers, but it's stuff that you want to ask for depending on the nature of your case. GPS navigation systems, similarly, are being used in all sorts of cases. It was introduced in a criminal non-jury trial and led to conviction of a New Jersey man for second-degree murder for intentionally running over a 12-year-old girl. Again, a case with no witnesses. The allegation was George Ford killed the girl to prevent her from reporting what he had done to her when he was alone with her in a few hours before she died. He claimed that he had hit the girl by accident after he had taken her to a farm he owned near Binghamton. The critical evidence came from the GPS device that, ironically, his estranged wife had put in his vehicle because she suspected he was having an affair. So she was more than happy to turn this information over to the police, and the data showed that he had not been at this farm where he claimed to be before the girl died, and showed that he had killed her, and he was near the location where her body was found, so he had not run her over where he had claimed. That led to his conviction. Similarly, data from a GPS device that was installed by police was key evidence that led to the conviction of a gentleman named William Jackson, who murdered his daughter. He told the police that his daughter had been kidnapped on her way to school. They searched his house and his truck and couldn't find any evidence, but still suspected him and got a warrant and put a GPS on his truck. And the data from the GPS device led them to a storage unit, an empty grave, and a new grave where they found the girl. So based on that, the only thing that connected him to these locations was this GPS information. Based on that, he was convicted of murder and sentenced to 55 years in prison, and that conviction was affirmed by the Washington Supreme Court. In another interesting, ironic case, a guy named Paul Seidler in Wisconsin was convicted of stalking his girlfriend from the very evidence from the GPS device he had put on her car to stalk her. So again, if you're looking to get a restraining order or something like that, or you have that kind of a harassment case, that kind of information is something you want to think about, you might want to ask for. And the prosecutors in that case used the data to support their case and described the GPS device as, quote, the best witness. So this device was the witness in the case, as again, there was no eyewitness as to how he was following her. He claimed it was all coincidence. It's also been used in a civil case in a wrongful termination action that was brought by a cable company employee against Pac Bell Telephone Company. Pac Bell terminated this guy Blake Smith after his vehicle was stolen, and they fired him for not maintaining the vehicle, not maintaining company property properly, and also because they found that he had lied during the investigation of the theft. He claimed that he had parked his truck, taken the keys out of the ignition, and locked the truck. However, they concluded he was lying because there was a GPS device in the truck that showed the truck was idling at the time it was stolen. So clearly he had not taken the keys out. So in an affidavit that it filed in support of its motion for summary judgment, Pac Bell explained that the GPS technology in its truck, this is how they authenticated and showed it was valid. It generates a report in the form of an Excel spreadsheet that records data, including the time and location of every vehicle, every time the ignition is turned on and off, the time and location of the vehicle every 7 seconds, and the time and location of the vehicle every 1 mile it's driven. That satisfied the court, and the court granted Pacific Bell's motion for summary judgment, finding that the termination was appropriate because he had lied during the investigation. Again, the evidence that he had lied, there was no witness. It was the technology. So I am going to skip wearables because it was covered earlier by Antigone, and those were interesting cases, and we'll see if Ms. Risley is convicted of filing a false report in Pennsylvania. But now, moving on to dashboard cameras and red light traffic cameras. So these are also effective evidence in civil and criminal cases. In one case, evidence from an onboard video camera combined with cell phone records led an Alabama jury to award $1.3 million to a driver who was injured in a crash caused by a truck driver who was distracted because he was on a work-related phone call at the time of the accident. So again, there were people who saw this, but the key evidence at the time for this verdict, the jury saw video footage from the camera that had been in the school bus, which the injured person collided. And additional evidence came from cell phone records of Gregory Moore, who was the guy who was taking a business-related call at the time, and his negligence caused the accident and caused the injured person to hit the school bus. So based on his cell phone records, which showed that he was on a business call at the time of the accident, combined with the camera footage from the bus, they were able to put this together, showed it to the jury, and based on that, the jury found Moore and his employer liable for the damages, which came to $1.3 million. There was also a criminal case in California using this technology where a woman named Carmen Goldsmith was convicted of failing to stop at a red light in an intersection based on photos and videos generated by a red light traffic camera. And at trial, the police investigator testified that the computer system records every event that occurs in the intersection after the traffic light turns red and stores the information on a hard disk at the scene. Technicians retrieve the data during the day through an internet connection, and it produces 3 photos and a 12-second video. So there's a lot of evidence to show a jury in these kind of cases. And the system also puts a data bar in all 3 photos showing the time, date, location, and amount of time the traffic light was red at the time the photo was taken. And it also shows the vehicle approaching the intersection and moving through it. Goldsmith's conviction was affirmed by the Appellate Division of the Superior Court, the Court of Appeals, and the California Supreme Court based on this evidence. And in response to her claim that the camera evidence wasn't adequately authenticated, the California Supreme Court said that it had frequently approved the, quote, substantive use of photographs as essentially a silent witness to the content of the photographs because, quote, to hold otherwise would illogically limit the use of a device whose memory is without question more accurate and reliable than that of a human witness. That's the California Supreme Court. Query if that's good, bad, but that's where we are. It's quite a sweeping statement. Event data recorders are another kind of technology that have, as the picture shows, become the witnesses in cases. There was a case called Commonwealth versus Zimmerman where the Massachusetts Appellate Court held that the trial court properly admitted evidence taken from the event date recorder. That's like the black box you've heard of that's in cars. And it's actually in most cars. It's not really cutting-edge technology, but it's in most cars, and it collects a lot of information. So Zimmerman lost control of her GMC Yukon, spun it around, slid off the road, and killed the passenger in the car. The weather was bad at the time, and the accident investigator found there was probable cause to find that the evidence of the crime would be found in this black box. Zimmerman claimed she'd been driving between 20 to 30 miles an hour, but the data in the vehicle from the EDR showed that 5 seconds before the accident, she was driving 58 miles an hour. And she was charged and convicted of operating her vehicle at excessive speed and criminally negligent operation of a vehicle. Another case in Florida, Matos versus State, the court affirmed the conviction of Matos on 2 counts of vehicular manslaughter. Again, the key issue in the case, the speed that he'd been driving at, was established solely through this black box. Matos struck and killed 2 teenage girls, and the data from the EDR in his car showed that he was driving 114 miles an hour in a 30-mile-per-hour zone 4 seconds before the crash, and that he was going 103 miles per hour within 1 second after the crash. The defense's expert had estimated the car speed that was 56 miles per hour. So in a battle of the experts and battle of technology, the technology from the EDR in his car led to his conviction. Similarly, there's another case, People versus Hopkins. Data from the airbag module in the defendant's car helped the prosecutor show that get him convicted of depraved indifference murder and defeat the motion to dismiss the indictment. In that case, the airbag data showed that at the time of impact, he was driving between 65 to 70 miles per hour. 5 seconds after the impact, he was going 104 miles per hour, and 3 to 4 seconds before impact, he was going 106 miles per hour. Posted speed limit, anybody have a guess? 30 miles per hour. So it also showed that he didn't apply the brakes until 2.5 to 3 seconds before he crashed into a line of cars that were stopped at a red light. Again, there was no witness that could prove just how fast he was going, but his own car proved it and got him convicted. Another thing that we all love, especially if you're in New York, New Jersey area, we love Easy Pass. Easy Pass is our friend. It saves us a lot of time. We all kind of know we give up a lot of privacy, but we make the trade-off. Easy Pass in New Jersey has played a key role in cases there. In a civil case, this SSS versus MAG case, the New Jersey Appellate Court reversed the lower court's entry of final restraining order in a domestic violence case based on the improper exclusion of Easy Pass evidence. So a woman claimed that she had been assaulted by her former boyfriend after he picked her up in Newark at 9 o'clock, that he took her to Jersey City at 9:30 and assaulted her, and took her back to her school in Newark at 10. If you drive in New Jersey, you know that's not really doable. But anyway, the defendant denied this and said nothing had happened. He had a letter from his employer showing that he had been at work from 8:35 until 5 p.m. And he also offered up his Easy Pass record showing that his transponder had shown that he had crossed the Bayonne Bridge into Brooklyn at 8:16 that day. He argued, and again, anyone who drives in New York will tell you this, he could not possibly have crossed the bridge at 8:16, gotten to work at 8:35, and been at Newark at 9. So the appellate court found that essentially this was a he said, she said dispute. There were no witnesses, no other exhibits, and that the Easy Pass transponder evidence was critical to his defense, and its exclusion on hearsay grounds was improper. So it was remanded for a new trial where that evidence was going to be admitted. There was another case, State versus Melanie McGuire, also in New Jersey, where a New Jersey woman was accused of killing her husband and chopping him into pieces and putting him in suitcases and disposing of him around here in Delaware and Virginia. Some of the evidence that helped convict her was information from the Easy Pass transponder in her car that showed that she traveled from her house to Atlantic City allegedly to create false evidence, trying to give the implication he was still alive and gambling in Atlantic City. She had called Easy Pass trying to get them to remove 2 45-cent charges that showed her traveling near Atlantic City, which she claimed was incorrect. Easy Pass had refused to take those off because it had the evidence to support that she was there. They also introduced Easy Pass transponder records from her vehicle and her parents' vehicle that suggested that she had picked up her children on the day that she was alleged to have disposed of the husband's body, dropped the kids off with her parents, then traveled back to her house, and then traveled to Delaware, where some of her husband's remains were later found. So social networking sites are also a treasure trove of relevant data in litigation. In this case, Reed versus Ingram and Smith, a woman sued her employer and a coworker from damages from alleged sexual harassment. The defendants asked for production of postings and photographs from private portions of Reed's Facebook account, and they argued that the postings and photographs on the public portions of her account contradicted claims in the lawsuit, so private portions were also likely to contain relevant information. The court reviewed that and found them to be probative of her mental and emotional state and concluded that her private postings could also contain relevant information about her emotional state. The court went beyond that and found that postings by third parties of her social activities were discoverable because they could be relevant to her claims of emotional distress, loss of enjoyment of life, and could reveal the names of potential witnesses in the case. So she was ordered to produce social media postings and photographs, and listen to how broad this is, that related to any emotion, feeling, or mental state or related to events that could be reasonably expected to produce a significant emotion, feeling, or mental state, including posts made by third parties containing their observations of her and her responses to those posts. All that information was going to be turned over because it was relevant to her claim of loss of companionship, loss of enjoyment of life as damages for alleged sexual harassment. And this is not uncommon. Also in personal injury cases, Facebook and MySpace pages have been ordered to be turned over relevant to this claim for loss of enjoyment of life. In one case, the plaintiff alleged she was permanently injured as a result of an accident and couldn't participate in certain life activities due to her injuries. The defendant argued that information on the public pages of her Facebook pages showed she had an active lifestyle and that one had a picture of her sitting outside her house smiling, even though she claimed she was bedridden and confined to her house as a result of her injuries. So, based on these contradictions, the court concluded it was reasonably likely that if this is what she had on her public-facing pages, there might be additional relevant information on the private pages and that those had to be turned over to the defense. Similarly, online job search engines have been required, the data from that to be turned over in litigation. In one case, a defendant argued that the job searches conducted during the course of the plaintiff's employment, so while he was still employed by the defendant, related to his commitment to his job, his perspective on the working environment at the company, and any alleged emotional distress he had suffered. So these searches that were conducted after his employment ended also related to his claims for emotional distress and attempt to mitigate his damages, and those were ordered produced as well. These have also been used in criminal cases. In a terrorism conspiracy case called U.S. versus Hassan, the prosecution used the defendant's Facebook postings to demonstrate their violent tendencies and commitment to terrorism. And in those cases, information that had been posted on Facebook showed allegedly the defendant's belief in violent jihad and willingness to further violent causes, which was not helped by an email he had sent asking somebody to try to take that information off his Facebook page. So based on that and other evidence, the defendants were convicted of conspiracy, and those convictions were affirmed by the Fourth Circuit Court of Appeals. Text messages and tweets have also been admitted and been key in certain criminal matters. One case was the criminal trial of Dharun Ravi, who is a Rutgers student who is charged with witness tampering, invasion of privacy, and bias intimidation when he activated a webcam that showed his roommate having sex with his homosexual lover. And there was a question of whether or not the roommate was out or if he was outing him. So regardless, it was pretty bad evidence. In the witness tampering case, they had a text message that he had sent to his friend Molly Way, who was being interviewed by the police. As she was being interviewed by the police, he sent her a text message that said, "Did you tell them we did it on purpose? What did you tell them when we asked why we turned it on? I said we were just messing around with the camera." So after the trial where he was convicted of witness tampering, one juror stated that those texts convinced her that he was tampering with a witness. So that text was the evidence that got him convicted on that charge. Similarly, he was way too into social media and used additional texts and tweets that proved that he had invaded his roommate's privacy and intimidated him. In one tweet, he wrote, "Roommate asked for the room. I went to Molly's room and turned on my webcam. I saw him making out with a dude, yay." So that was an example. Interestingly, he also tried to introduce a text that he had sent to his roommate trying to prove that he was not homophobic. And he wrote, "I've known you were gay and have no problem with it. In fact, one of my closest friends is gay, and we have a very open relationship." The jury didn't buy that, so that self-serving text did not help him, and he was convicted on those charges as well. Blogs and chat rooms, also information and data from that have come into litigation. In a Louisiana case, a father who did not get custody of his child introduced information from his ex-wife's blog post trying to show that she was an unfit parent or had been having an affair at the time they were married. Also claimed that the fact that she blogged so much showed that she didn't spend enough time with their child and shouldn't have the child. The trial judge stated that while the internet statements were evidence that could have been used to impeach his ex-wife potentially during the divorce, they occurred after the trial and weren't made under oath, so didn't provide the basis for a new trial, and also noted more generally that it was not clear that they were important to the case. There's another case with a chat room, Glazer versus Fireman's Fund, where the plaintiff was ordered to produce copies of all her chat from Live Person, which apparently is a website that offers online advice and professional consulting services through psychics. Go figure. So apparently in that case, the plaintiff had chatted with some of these online psychics on numerous occasions and emailed portions of some of those online chats to her work email account. This is while she was still working for Fireman's. She later sued Fireman's Fund for allegedly retaliating against her after she complained about discrimination against non-African Americans and claimed she'd been wrongfully terminated because of her religion. Fireman's Fund put in place their hold, reviewed some of their documents, came across these chats that she had emailed to her work email account. So based on a review of that, the court agreed with Fireman's Fund that all the chats appeared to be relevant to one or more of the issues in the case, and including her opinions about how she was treated during her employment at the company, and had to be produced. And just finally, there's one more case where emails, which are coming in all the time. There's a case called Arroyo versus Volvo, where emails sent by company employees showed that they had discriminated against a woman who was in the reserves based on her military service and because she had post-traumatic stress disorder. And the Seventh Circuit Court of Appeals found that the district court had underestimated the strength of the emails as support for her case. Some of the emails were pretty bad. They said things like, "Are we required to give her the day before and after for travel, that is to military service? I find myself with a dilemma if I were to discipline a person for taking too much time off for military reserve duty. I certainly give her credit for serving our country, but of course I'm also responsible for our business needs." Not something you want to put in email. While she was in Iraq, one of her supervisors complained in writing that she wasn't checking in frequently enough, which was making scheduling difficult. In response to that concern, the head of HR emailed back, "Unfortunately, there isn't a lot we can do. Per the law, we have to wait for her. Sorry, it isn't what you want to hear." And there was another one that showed that while she was hospitalized for PTSD, even though she had told Volvo, which was her employer, about that, some of her coworkers and supervisors were joking and claiming that there were rumors about her not being there, claiming that she was on vacation in Hawaii. And one, as if it couldn't get worse, wrote an email opining that she was really becoming a pain with all this. So these are reported cases, and they're not all the cases that are out there. They're just kind of an overview to give you an idea that this technology is out there. This is what's being introduced as evidence already. This is not the future. This is what's going on now. It's not just in civil cases, but in civil cases, it's leading to $1.3 million jury verdicts. It's leading to people being convicted of crimes, to people having to plead guilty because there's incontrovertible evidence or, based on the CSI effect, evidence that juries are very inclined to accept. It's valuable to your client. It's a disadvantage to your client if you don't know to ask for this stuff and at least try to find it. You may not have it in every case, but these cases show it can be extremely powerful and it can be case dispositive. So I urge you to embrace it because it's not just the future of litigation, it's litigation now. And if you know to ask for these things and know how to use this information and your adversary doesn't, you're definitely in an advantage. And for those of you who litigate and try cases, anywhere you can get an advantage, you want it. So this is definitely one way to do it. Thank you very much.